pretrial motion in California high school mock trial. This is a constitutional argument at the beginning of the mock trial competition where each high school has one student playing an attorney arguing the pretrial motion about a certain piece of evidence that should or should not come into trial. So let's back up a moment. Mock trial is an academic competition team sport. A high school team has to put on both sides of a criminal case, with students playing both attorney and witness roles, as well as clerk and bailiff roles, prosecution and defense. When they actually compete, only one of those sides would compete in any given round against another high school team. So they put on a mock trial or a fake trial based on a fake set of facts. So the beginning of the competition are introductions, and then comes the pretrial motion, wherein each side's one pretrial attorney will argue the motion. With California mock trial, we deal with criminal cases, and so the pretrial motion is usually a constitutional argument based on one of our rights from one of the amendments to the United States Constitution. This year, as an example, in 2022, we have a Fourth Amendment right, which is the right against unreasonable searches and seizures. Let's break down the pieces of the case packet for you. The first important item will be the fact situation. You should know and be able to quote that the fact situation is an incontrovertible set of facts. So if any of the witness statements contradict what's in the fact situation, that witness is being incorrect, lying, not telling the truth. Then we have a set of stipulations that help everybody move the case along so that we don't have students fighting about side issues like, well, why didn't they talk to a dozen other people? We can talk about stipulations in another video. There's the section on the pretrial argument, which is going to contain snippets of cases. That means pieces of real cases from out in the world that real attorneys argue, but this will be called a closed library, in which only the cases and pieces of the cases that are in that packet are allowed to be argued in the actual mock trial competition. Then comes the set of the laws that are going to be involved at the trial, what crimes are charged, what those elements are of those crimes, and then we get the 8 witness statements in the packet. After the witness statements come the exhibits, which provide the handful of actual evidence that is documented, pictures of things, pictures of relevant items that the detective or the police gathered in the mock trial fact scenario that are able to be used at trial. And finally, the case packet has a long list of lots of rules that are involved in the mock trial competition. In addition, outside of the case packet, CRF has its own set of rules regarding the mock trial competition, and your county will have their own local set of rules that either adopts all of the CRF rules totally or has a handful that are different. We are out in Riverside County, where the county rules are primarily the state rules, but there are a handful of things that are different. So that's even more to learn, and we'll get into that in another video. So let's get back to pretrial. We primarily use the mock trial fact situation, the authorities that are in the pretrial section, and then anything relevant from any of the witnesses in the statements in the rest of the packet. Within the packet, in those statements and in the mock trial fact situation, there will be items that are in brackets that relate only to pretrial, and if the pretrial motion is granted, the motion to suppress evidence is granted, those bracketed items cannot be used at trial. And if the pretrial motion is denied, then those bracketed items can be used as evidence at trial.